Welcome to John Redmann, Power of Attorney, the show that aims to empower you through knowledge of the law. I'm attorney John Redmann, and today we're continuing our coverage of estate planning by focusing on the key legal documents that all adults should have and keep safe to protect their rights. We'll be joined again by attorney Rose Scher, who practices in estate planning law. She'll be on with us shortly, right after the break, to talk about estate planning and key legal documents. We'll be right back. Welcome back to the show. We all know that we should prepare for the worst and hope for the best, but so often people find themselves in an emergency situation without having properly prepared for it. On today's show, we're going to try to give you some great information about the legal documents you need to have on record to protect yourself in all situations. Rose Scher is our guest today. She's an attorney with the Sessions Law Firm who practices in estate planning. Rose, thank you for returning to the show.
Thanks so much for having me back, John.
Good. Well, listen, we did the show about living wills, fascinating discussion. That was just last week's show. For today's show, there's some other documents, and we're not going to be able to go in depth because we're talking about several different legal documents. But what I think would be helpful is we kind of sort of list the greatest hits or the most important legal documents that pretty much every adult out there should have or should at least seriously consider having and having it safeguarded. So we kind of prepared a list, but would you like to kind of tick off the most important legal documents that every adult should have?
Sure. So we talked about living wills last week, and that's definitely on that list. And let me just start with probably the most important one, which will be your last will and testament, or your will. And if you don't have a will, then your property is just going to go under the way that the law of Louisiana says it's supposed to go to. So your will can be as simple or as complicated as you want it to be. Right now, we've got two types of wills in the state of Louisiana. We've got a notarial testament and an allographic will, and the notarial testament is the one that's prepared by an attorney and it's signed before a notary public and two witnesses. And the allographic testament is entirely handwritten, dated, and signed by the person who's making it.
Okay, so the will is your wishes, what you would like to have happen with everything that you possess, everything you have in your estate, where you want your possessions to go.
It's where you want your possessions to go, but it's also who's going to be managing your possessions, who's going to be managing your estate, who's going to be going to court and getting your estate open, who's going to be deciding how to interpret the terms of your will, and stuff like that.
Okay, and the benefit of having an attorney involved, one who practices in estate planning, ideally, is that's much more likely to be held up. It's going to hold up in court, not be challenged as a fake will or something that the nephew who wants his hands on the estate, they didn't make that as a forgery. The allographic will is one that is done all in hand. You can't type it up.
You can't type it up. It has to be in your own handwriting, and you have to write it, and you have to date it and sign it, and it has to be when you read it, it has to show that it's your will. I mean, you could say, this is my will, which will be great, or you could say, I'm leaving all of my possessions to this person if I die, but it just needs to be clear in the text of the document that it's actually your will and it's not just a note to somebody.
Now, the two accomplish pretty much the same thing?
You know, they can accomplish the same thing, but I would say that it's always better to go to an attorney and have a notarial testament done. Really, the best way to avoid litigation among your family members and your relatives is to have a really good, well-drafted will.
Okay. All right. Well, that's the will, and that's the summary. And we're not going to be able to get into a whole lot of detail because we want to give people sort of a short little snippet or summary as to each legal document.
Sure.
We already mentioned living wills. We can sum that up in a minute, but let's list all of them. Living wills.
So there's a financial power of attorney and a medical power of attorney and your will and your living will. And that's when clients come to our office for estate planning documents, those are generally the documents that they get. Sometimes there's other issues involved and we'll do a trust for them, but for the most part, those are the four key documents and common documents.
And what we talked about before is it's not specifically a legal document, but to maybe round things out, we would also remind people that there are other documents that can be very important, like insurance documents, real estate documents, like the deed to your home, custody or family court documents, insurance papers for your home, your car, that you want to basically you create a list of these other documents and keep them all somewhere handy. That could be a document you create, and you want to make sure you know where those documents are. That would be maybe to round it out, not necessarily a legal document. Does that sound fair?
Well, and just to add a few things to that list is with your insurance policies, you want to make sure that your beneficiary designations are up to date.
That's who receives the insurance proceeds.
Exactly, for life
there's a
insurance.
claim that needs to be made. Yeah.
Right. Any type of insurance policy or anything else where there's a beneficiary who's designated, you want to make sure that that is updated. And also, everybody's using email now and online banking and doing a lot of things over the internet. So you want to make sure that you've got a list somewhere. And I feel like there's an IT person somewhere who's pulling his or her hair out. But you do want to have a list of all of your usernames and passwords if you think that for some reason you might become incapacitated.
In a very safe place with a very trusted person.
Exactly,
right?
exactly. Somebody you trust should know where that list is.
Okay. All right. Well, now why don't let's backtrack a little bit. You gave us a good explanation of what goes in a will and the two types of wills: the one that you write out in your own hand, or the one that you do with an attorney that's notarized with two witnesses.
Right.
You mentioned medical power of attorney and a financial power of attorney. Tell us what each of those are.
Sure. So with the medical power of attorney, it's really it's really where you name somebody who's going to make medical decisions for you if you're incapacitated. And it's not the same thing as a living will, although it can include some provision, a similar provision that would be in a living will. But a medical power of attorney can authorize someone to authorize a surgery on your behalf or get a hold of your medical records.
This is something that allows other people to make decisions on your behalf while you are incapacitated.
Exactly. And being incapacitated can mean a lot of different things. A lot of times we explain this form to clients by saying that if you are under anesthesia and you're being operated on and the doctor needs to make a decision about whether to amputate your leg or another type of decision, and the doctor can't wake you up and say, do you want me to do this? And it's a really important decision that needs to be made right away. So that agent, the person who's named as your agent and your power of attorney, would then make that decision.
Okay. And financial power of attorney.
Okay, so it's similar to the medical power of attorney in that you're naming someone to make decisions on your behalf. The financial power of attorney, as with the medical power of attorney, can be as limited or as general as you want it to be, which is why it's good to go to an attorney who specializes in this area. You can give someone a power of attorney a real estate power of attorney to, sell your house if you live out of town. If you're doing estate planning documents and you're executing this broad general financial power of attorney, it's somebody who can pay your bills when you're incapacitated, somebody who can make donations. Let's say that you're the agent for one of your parents who's incapacitated, and for Christmas every year, Pawpaw gives all of his grandkids a nice Christmas present, so you can make those gifts if that's included in the power of attorney. Right.
So, but the important point there is when you draft that financial power of attorney, if there's something specific like Pawpaw wants every Christmas each grandchild gets $100, you might want to specify that in the financial power of attorney and give that permission or power of attorney to that designated person who can then write those checks on your bank account.
Right. So exactly. So you want to be general in the sense that you don't want something to come up where the agent really needs to make a transaction and needs to do something, and they're limited by what's in the form. But you do want it to be a little bit specific, because if you don't want them to be able to just run with the ball. So it's really a personal preference.
Sure. Well, I could just see, maybe some other family member who wants to challenge that family member who gave away $1,000 of grandpa's money to the grandkids, said, well, I don't remember grandpa saying that you could do that. If it's in that power of attorney, you're not going to have a problem.
Right. Well, right.
I mean, they'd be hard pressed to give you a hard time.
Exactly.
But the general power, maybe general power to interact with representatives of the bank on your behalf. When somebody at the bank says, well, you're not Pawpaw, I'm not going to talk to you about Pawpaw's financial matters. If you provide them that financial power of attorney that gives that permission, then you can talk to the banker about Pawpaw's financial matters, right?
Exactly. And actually, that's another interesting point that you brought up, John. A lot of banks have their own forms, and if you bank with one institution, sometimes it's a good idea to use their form, which it doesn't mean you shouldn't have just a general power of attorney, but all institutions aren't the same, and all customer service representatives aren't the same, so it's always better to be more prepared than less prepared.
Okay. And this medical power of attorney, financial power of attorney, that does bring us back to living wills. And of course, we spent a lot of time talking about it, but an interesting statistic that we came across in researching for the show is that while these living wills are so important, the statistics on the screen, only 41% of American adults actually have a living will. Living wills are much more powerful than a medical power of attorney. Like you called it in the show we taped for last week, it's a pull the plug document, a lot of people call it. It respects the wishes of the person to whether they want to have life-saving measures brought in, or it gives the power to a spouse or a family member to make that call if you're incapacitated and you're not expected to ever come out of the coma or the terminal illness, right?
Right. And I think what really led a lot of Americans to care about having living wills was the Terry Schiavo case.
Right. Big case in the news, national news for weeks and weeks.
It went on forever. Literally, Ms. Schiavo was on, I believe, life support for about 15 years.
In Florida.
In Florida, and every court got involved, from the Florida State Court up to the Supreme Court, and so it was quite a litigation.
Yeah. And just for the people who maybe they're too young or they don't remember, this lady was on life support. It was a fight between her spouse and her parents as to whether or not to pull the plug. She did not have a living will.
Right, she had no living will, and her parents wanted her to stay on life support, and her husband wanted to pull the plug, and they ended up pulling the plug, but it took a very long time, and it created a lot of discord and tension between her parents and her husband, and it was very, very ugly and very painful. And
an awful situation where she was awfully young. I mean, she wasn't 90 years old. She was a middle-aged lady, let's say, and a big court battle, about whether or not she had any brain activity, whether there was any chance, one chance in a million she'd come back, one chance in 500. But the doctors pretty much agreed that she didn't have brain activity. Ultimately, they did pull the plug on her. Right. And many Americans thereafter said, well, whatever my wishes are, I better put it in a living will so my family doesn't get torn apart. My spouse's family, my spouse, and my own parents or children don't have to get into this battle. These are my wishes, right?
Right, and that's true. It really brought the issue under the national spotlight. But Louisiana, since 1984, has had a statute where you can have a living will, and it's been something that people have been doing in this state for quite some time now.
All right, well, let's take a break now, and coming up next, we will continue our discussion with Rose Scher, and we'll also get to some of our viewer questions. Welcome back to the show. We are continuing our discussion with Rose Scher about estate planning and the important legal documents people need. Let's get back to the discussion with some viewer questions. One viewer asked the question, what does it cost to gather up and create these legal documents?
Well, that's an interesting question, and the cost can really vary. At my law firm, we charge by the hour for the work that we do, and each attorney has a different billable rate based on that attorney's level of expertise and experience. So the partner who's a specialist in this area would obviously bill a lot more than a younger, more inexperienced associate. And then we also have paralegals in our section who do a lot of the work also. So that's how we charge for it. So I can't give a flat fee, although I believe there are some attorneys who do charge a flat fee for documents.
So you could shop around, but sound advice, and I can certainly say this: wherever you go to get help, a law firm that does have an estate planning or estate administration section, or maybe that's all they do, they are going to be that's a much safer bet to go to people who focus their practice on that or have a section that focuses on it. That's a much safer bet. But you can get price quotes. But also it depends. Like if you have an estate that's worth $2 million and you have 10,000 different things you want to have done with different parts of your state, that will is going to be a very different and much more expensive will than if all you have is maybe a house and some furniture in the house and a little bit of savings, and you want it all to go right to your kids, share and share alike, right?
Right. Well, exactly. It depends on what you want to do with your estate. And even if you have a smaller estate, but you have a lot of different people who you want to leave some money to or an item, you could have a complicated will. It depends on what you have, what you want to do, and also, I mean, we're always trying to tailor our documents to whatever the client needs, and so that could take more time, that could take less time.
Depends on how complicated the request of the person doing a will. One thing I forgot to ask before we get to the next viewer question, an important matter is where do you safeguard these important documents once you've created them? And maybe we can get sort of the shorter answer now. I know we spent some time talking about it last week, but a shorter answer right now.
Right, so it's really important, like you said, to safeguard these documents, because there's no point in having the documents if they're not going to be kept in a safe place. And what we do is when a client comes to meet with us, we will actually take the client's original will and put it into the vault in our law firm, which is fireproof and waterproof. And we'll give the client a certified copy to take home with him or her. And we'll also store originals of the powers of attorney in our vault also. Some clients have a safety deposit box where they want to keep their documents, but I would say that the best place to have them is a place where your family member can access them and knows that they're there and knows where those originals are.
And also because if something happens to you, you want other family members to be able to access the documents. You have at least one trusted person who knows where to find the documents, and other people know you do have a living will if you have one, you do have medical power of attorney, you do have financial power of attorney, you do have a last will and testament. So your wishes, if you've gone to the time and trouble of getting them down on legal documents, somebody can find them and then carry out your wishes.
Right, that's exactly it. And so you always want to keep a copy of everything. And I'll generally, when I give clients certified copies, I'll stick my business card, I'll paper clip it to the copies. So if for some reason somebody finds the documents, then they can give our firm a call. And at least if we don't have the original documents, we can try to lead that person in the right direction to find those documents.
Excellent. All right, well, let's get back to the viewer questions. One of the viewers asks, if my parents die with debt, or if my parent dies with debt and I'm the heir, does my inheritance go to paying off the debt before it goes to me?
Well, the short answer to that question is it does. That your parents' debt would then be the debt of the succession. And so what you want to do is you want to decide whether the debt is larger than the assets.
Sure.
And
whatever the value of
exactly
the inheritance is.
So it might not be worth it to actually get your inheritance because there may be more debt than the value of your inheritance.
Okay. So you need to evaluate that.
But you don't personally pay the debt out of your own pocket. It comes out of your inheritance.
The children or the people who would otherwise inherit, they don't inherit debt, and they can turn away the succession altogether if the succession or the estate owes more money than there are assets or value in the estate. Correct?
Exactly.
Okay. Next question. Do the children of a deceased person who aren't designated in the parent's will, are they entitled to a claim on any property formerly belonging to the deceased?
That's an interesting question. And that's a yes and no kind of question. So if you have a will and it's validly executed, then those people who are named in the will are the ones who are going to inherit, and they're going to inherit under the terms of your will. And if you leave out your kid, you leave out your kid. We do have forced heirship in the state of Louisiana, and it's limited, but anybody who's under the age of, if you have a kid who's under the age of 23, then that kid actually could be considered a forced heir and could inherit, or if the kid's if it's a very sick child who has a disease, and this is getting into more specific areas of the law, but generally it depends on the kid who's left out of the will and their situation.
There may be a reason why the child would disinherit it or other things like that, but generally speaking, if the child is under 23 and there's not extenuating circumstances, the law requires they get at least some percentage, some portion of the estate.
Exactly.
Okay. Next question. Will the person to whom I give power of attorney be able to use my bank account?
Well, it depends on the type of power of attorney and what it says, but generally, if you've executed a financial power of attorney and you've named someone as an agent, then they can access your bank account. Now, they're not supposed to be using it for themselves. They're not supposed to be taking the money and transferring it into their bank account, but they will have access to your bank account.
The power of attorney is not a license to steal, is what you're saying.
Exactly.
They're supposed to be managing your affairs in your shoes for you.
Right. So, but if you don't want that person to have access to your bank account, then you should make that a part of your power of attorney, that this person has the power to do X, Y, and Z, but that doesn't include accessing my bank account.
Okay. Now here's the question. Obviously, somebody found some good legal words, and I remembered from law school days in successions classes. Are testate successions less expensive than intestate successions? So I guess you have to tell people what both of those words mean.
So a testate succession is a succession where there's a will, and an intestate succession is a succession where there isn't a will. And there's no yes or no answer to that question. And just like the costs for making a will can be different depending on what you have and what you want to do, the cost of a succession, can vary. With the testate succession, since everything is laid out in the will, it could be something that's very simple to do, and so it might not cost that much. With an intestate succession, there could only be one heir, and there could be very little property, so that could be very easy to do. But a lot of intestate successions are actually pretty complicated because you've got to track people down, you've got to track property down. It makes it a little bit more different, and I think that's why the question was, are testate successions less expensive? Mm-hmm. And the answer is sometimes, but it depends on what's in the testate succession.
But conventional wisdom is, if you have the opportunity, anybody who thinks about it should have a will prepared, or do one themselves, but prepare a will that says what you want to be done with your property after you pass away.
Right. Well, I will say this about testate successions. if you don't have a good will, if you don't have a well-drafted will, and you have a will that's ambiguous, your testate succession can definitely go into litigation, and that can make it extremely expensive.
Yeah, in other words, somebody says, well, I don't need a lawyer. I'm just going to write down on this piece of paper what I want to have happen with my estate, with whatever everything I die possessed of, and they do a poor job of it, and they, like you said, they're ambiguous about who gets the car and who gets the refrigerator and who gets the money in this bank account. And that can lead to a lot of fighting over what exactly you intended to do with your estate. Maybe you leave some things off the will and nobody knows what's supposed to be done with that. And maybe you have children under 23 and you didn't realize they're supposed to inherit a certain percentage and you didn't leave that for them. That can lead to fighting in the courts, not to mention fighting within the family, right?
Well, right. So if you want to write your own will, you run into a lot of those problems. But there's also wills that are drafted by attorneys that don't contemplate things that could happen in the future. So you want your will to be fluid so that it can, it can last for a long time, because a lot of people come in for estate planning and then they don't come back again for estate planning, and they don't get their documents updated, and sometimes they don't need to get their documents updated. And so at our firm, we like to draft our wills so that it'll continue to be a good will,
it'll anticipate,
right, we
future
anticipate
contingencies, like a new child being born,
exactly.
things like that. Well, I'm afraid we have run out of time. Thank you so much for being here and answering these important questions.
Well, thank you so much for having me.
Okay. We've run out of time, but we want to thank our guests for providing such great information and insights over the past 2 episodes. Remember, you can learn all about everything we've talked about today on the show's website, johnredmannpoa.com. You can also watch every episode of the show and submit your legal questions that we'll try to answer on the air. Thanks to you for watching, and we will see you next time on John Redmann, Power of Attorney.